Hello, my name is Crystal Dahl, and I am the Online Communications Manager here at Meritas. I would like to welcome and thank each of you for joining us on today's webinar, How the Trump Administration is Changing U.S. Immigration. For those of you that are new to Meritas, Meritas is an established global alliance of closely connected yet independent law firms that each offer a full range of high-quality, specialized legal services. We were built upon a rigorous system for monitoring and enhancing the quality of our member firms and have been connecting clients with carefully qualified business legal expertise in 240 markets around the world since 1990. Meritas capability webinars are regularly presented by Meritas members. Before we get started, I'd like to quickly go over a few housekeeping items. Meritas now offers the ability to listen to our webinars through your computer speakers. If at any time you have any difficulty hearing the presentation, you may call into the associated telephone line instead. All phone lines will be muted. If you experience any difficulties, please press *0 at any time to connect with a support technician. Since you will be muted, if you have a question, please ask via the chat feature found on the left-hand side of your screen. Lastly, in the next few days, I will distribute a copy of the presentation, a recording of this webinar, as well as Joel's contact details. Our presenter today, Joel Pfeffer, is a partner of our Pittsburgh, Pennsylvania Meritas member firm, Meyer, Unkovic & Scott. He is the chair of the Corporate and Business Law Group, a member of the International and Immigration Law Group, and is a member of the firm's Management Committee. Mr. Pfeffer also works primarily in the areas of immigration, nationality, and corporate law. With that, Joel, are you ready to get started?
I am. Thank you very much. I will be speaking for about 30 minutes about how the Trump administration is changing U.S. immigration the first 40 days. I will be available to answer questions on the chat line after that for up to half an hour. And if anybody wants to contact me privately, feel free to do that. I've divided the talk into 4 topics. Travel to the United States, initiatives that affect U.S. businesses and business travelers, refugees and illegals in the United States, and predictions of what lies ahead. I have 4 predictions about what lies ahead that I'm sharing with you. I have a few more, but they're not related to business immigration or any of these topics. Excuse me. Just a brief overview of what happened here. The administration on January 27th issued 3 executive orders on immigration in sort of an unprecedented way. They just issued them. That caused a lot of chaos and confusion. It stranded people at airports. It had people from these 7 countries have to turn around and go home. It's not a pleasant experience, and in many cases, visas were revoked, causing now people have to go back and apply for new visas. At the time, the President, the executive orders issued these. Travel became difficult for people from 7 countries: Libya, Syria, Iraq, Iran, Sudan, Yemen, and Somalia. Now, these countries have previously been identified as countries that promote terrorism, and there were previously there still are special rules that apply to these countries. We'll get to that a little bit later. But any citizen, and when during the period when these executive orders were in effect, prior to when the court issued the various courts issued restraining orders against them. I believe it was on February the 6th that finally the temporary restraining order became effective for the whole country. During that period, it was unclear whether or not if you had dual nationality, this applied to you. It was unclear whether if you were national in one of these countries and a permanent resident in the United States, somebody with a green card, whether this travel ban applied to you, and that created unprecedented chaos and confusion at airports. There was concern among the immigration bar about whether cases could proceed, even cases of people who were present in the United States. It's caused anybody from any of those countries just to stay put, not to leave the United States, and it's created almost a hysteria in the United States for people who are in the process of becoming permanent residents. The anecdotal information is that it's causing a rise in the filing of applications for naturalization, and certainly the illegal immigrant community, the undocumented community, is certainly in a very difficult situation, nervous at all times. About the executive orders, many of the items in them, in the executive orders, are things that will require either a budget allocation from Congress, an act of Congress to change the law, or a regulatory change which will require a comment period under the Administrative Procedures Act. So a number of the items in the executive orders cannot be acted upon without somebody else doing something, Congress or the administrative agency. However, there are a number of initiatives in these executive orders that are really just items that are being brought back from the Bush years, things that the Obama administration had done away with, and certain other initiatives of the Obama administration, such as guidance on prosecutorial discretion. Those are being done away with. The one exception here that is not addressed in the executive orders is the DACA and DAPA memos. Those are memos that allow DACA is for what we call dreamers, children who came to the United States within a certain period of time, narrowed by the memo, will have the benefit of deferred action. DACA means deferred action for childhood arrivals. This was a big topic in the campaign. Number of the candidates pledged that on the first day they would rescind DACA. DAPA is for people who have, for parents who have children who, when they turn 21, will be able to qualify the parent for permanent resident status. That's subject to a court injunction right now, so it's not really relevant. But there were candidates who said the moment they are elected, they will do away with DACA, and that has not happened. I suspect it's not happened because ultimately the administration wants to see if they can promote some kind of immigration reform, and that would be part of the quote-unquote amnesty for certain classes of people. There are many people in the United States who came as children, and the DACA memo protects only a small number of them. Now, moving on to one of the Obama administration restrictions was for travel by visa waiver nationals who visited countries of concern in the last 5 years. That is a directive of the Obama administration that applies to these 7 countries: Libya, Syria, Iraq, Iran, Sudan, Yemen, Somalia. And what it says is that if you are a national of a visa waiver country, there are 38 countries whose citizens do not require a visa. It does not require you to appear at the U.S. Embassy and apply for a visa. You can enter the United States on your passport with something called ESTA clearance. Today, technically it's the Visa Waiver Program, but most people today call it ESTA, the electronic system that clears you. Every traveler from those 38 countries can enter without a visa. However, if you visited one of these countries of concern in the last 5 years, then you need to apply for a visa. So that's still in effect. That's an Obama administration restriction that recognized the status of these 5 countries as countries that promote terrorism. I should say that the press is reporting that the promised revised executive orders, the administration had either announced or leaked, I don't know which, that there would be a revised executive order on travel ban, another travel ban that they would hope would overcome the challenges that they've met in court to date. It will be published today. The press the media is reporting that that has been canceled, and that there's no word yet when that will be published. I think that what's happening here is that the administration does not want to make the same mistake they made before, and they are vetting. They're going through an approval process of the regulations through the various departments that are stakeholders in immigration and entry to the United States, to be sure that everybody's on board. It's also been reported that there will be a period between when the order is signed and when it takes effect, something that they didn't do last time, perhaps a bit of a rookie mistake. And what I think is going to be, what you're going to see in that revised executive order is that there will be increased scrutiny for citizens of these countries when visas are issued to them. So I think the quote-unquote travel ban that is coming down the pike will be related principally to screening, related to the issuance of visas at consular posts. And frankly, this is nothing new. Consular posts have always screened different people differently. Anyone who's had to do with consular processing knows that there are consular posts where there's different levels of scrutiny. If someone wants to come to the United States as a student from the United Kingdom, it's not the same level of scrutiny as if you want to come from some country in Africa or some high fraud country. It's just different. Every country is different. That's the world of visas, and I think that these new bans are going to focus on this historical distinction between countries with respect to the issuance of visas. All right, moving on to initiatives that affect U.S. businesses and business travelers. One of the initiatives in the executive order is an increase of 10,000 immigration officers to heighten security of U.S. businesses, particularly those in target industries. We are going to see what's called interior enforcement. That means that parts of the country that heretofore have not seen any kind of enforcement or any kind of action, any kind of relationships between the Department of Homeland Security and employers will now start to see that. As every business person knows, that when you take on a new employee, you have to complete Form I-9. This goes back to 1986, when prior to 1986 it was not illegal to hire an illegal alien. It was not illegal to hire somebody who did not have work authorization. But Congress in 1986 said that every employer must pass on the authorization of a new employee to work in the United States by reviewing their documents and filling out a Form I-9. The Department of Homeland Security and the U.S. Department of Labor have the authority to review these I-9s, to impose civil penalties, and in some cases criminal penalties against employers who are not careful about completing them, where there are technical mistakes, or where there are blatant employers who just look the other way with respect to clearly fraudulent documents. I think you can expect to see that there are going to be more and more, especially if these 10,000 officers are hired, there are going to be more and more businesses that are affected by I-9 audits, that businesses attorneys should tell their clients, and business people should be aware that this is probably coming down the pike, and that they need to audit themselves their I-9 forms, their intake processes, how they review the documents. The government has a manual called the M337 manual. It's available on the USCIS website. It's a manual of about 65 pages. There was a new one published, I believe last week or the week before. It describes to employers exactly how to review these documents, the intake processes that you have to undertake when screening new employees. It is a very complicated subject. There are many different documents that you can see. Most employers won't see too many, but there are a lot of documents out there that support the authorization to work in the United States. Some documents are temporary in nature, and employers need to be aware of that. Some documents are employer-specific. That means that if a person was approved to work for employer A, they cannot work for employer B without further authorization from the Department of Homeland Security. So employers need to be aware of that because there's going to be heightened scrutiny, and particularly in areas where areas of the country where we've not seen that before. But of course, some congressional appropriation will be necessary in order to engage more immigration officers. Another thing in the executive order is the development and implementation of a biometric exit entry tracking system for all foreign travelers to the United States. We do have a biometric entry system, but the government has had a difficult time. It's been a challenge for prior administrations to develop a biometric exit system as they have in some other countries. The exit system here works on a name and date of birth review of flight manifests, and it works pretty well. You can see a foreign national can see on the cbp.gov website goings and comings, and many of the for the most part, exits from the United States are tracked there. Even though there's no official tracking, there's no place where you go and say I'm leaving. It's just the government is reviewing the flight manifests for people departing the United States. Again, as I said earlier, visa issuance in certain parts of the world you can expect that to be under higher scrutiny, depending on the nationality, and the same is true with entry in the United States. The Customs and Border Protection officers are going to be looking more carefully at certain nationalities, whether that's indicated in the executive order or not. I think we can expect that to be the case. Moving on to refugees. The executive orders suspend refugee admissions for 120 days and discontinue the Syrian refugee program. For those of you who aren't familiar, refugees has been historically a way to arrive in the United States, for foreign nationals to arrive in the United States. Every year the President designates the number of refugees that will be admitted and from what parts of the world they will be admitted. The Obama administration in the last year admitted approximately 110,000 refugees. This administration is saying they're moving to 50,000 refugees. I think 50,000 was about the number that were admitted in the Bush years. In the Obama years, the number did go up closer to 100,000 each year. So that's how the executive orders affects refugees. Illegals in the United States. Nobody really knows how many illegals there are in the United States, but people are calling. People like me are getting calls every day. What can you do to help my friend or my worker or my house domestic help? And so let me just give you a brief overview of who can be helped. There's such a thing called non-quota family member. There are quotas and non-quotas. Quotas means there's a limited number of people who can come to the United States, and if you are related in a certain way to a U.S. citizen, the citizen can apply for you, and you can be in a quota line. Some of those lines are very long. It takes about 11 or 12 years for a U.S. citizen to bring a sibling to the United States. Non-quota family members have no, as the term implies, have no quota. So if someone wants to bring a spouse to the United States, a U.S. citizen wants to bring a spouse, a U.S. citizen wants to bring a parent or a child under 21, there are no quotas. If there is a relationship between the illegal national, the illegal alien, and a U.S. citizen in a non-quota way, a spouse, a child, or a parent, they can be helped. as long as the illegal enter the United States legally. So we look to see whether there is legal entry and overstay, or if the person had illegal entry, they snuck across the border, then they cannot easily be helped. Those cases require an extreme hardship waiver. There's a process by which the government tests whether or not the United States citizen will suffer extreme hardship if the close relative is deported or does not deported home or is not able to remain in the United States in legal status. And that waiver is issued by the embassy abroad, and it's a very complicated procedure how to obtain assurance that the embassy abroad will grant the waiver before sending this individual abroad to get the visa. In other words, it is not possible for people who did not enter legally to adjust their status in the United States to change to permanent residence without leaving the country. Once they leave the country, they're subject to a bar against reentry for most of the time up to 10 years unless they get the waiver. So this process of helping people out of this situation for non-quota family members when there's no legal entry in the United States is extremely difficult, and it's even more difficult because of the wait time for individuals who are in quota relationships, such as siblings, children of permanent residents who are there's not a U.S. citizen but a permanent resident, etc. Okay, let's go to the predictions. I think I went through this one before. Businesses should be ready for Form I-9 compliance audits, including unannounced inspections in target industries such as hospitality, farming, and food production. These can include unannounced visits with a subpoena or some other document that allows that to occur, or generally speaking, the Department of Homeland Security is required to give the employer 3 days notice before it can review the I-9 forms. Those I-9 forms will be reviewed for simple errors or for a pattern and practice of either errors or a failure to seriously review the documents in a way that could lead to criminal prosecution. Employers are not required to maintain copies of the documents that they review, but if they do keep copies of some, they should keep copies for all. I believe one of the things that I think is coming down the pike is a requirement to keep copies of those documents. I think by the time this is over, we're going to see that. Prediction number 2, over the course of time, Republican administrations in particular have sought to require E-Verify for all companies. E-Verify is now optional. It's an internet-based system that an employer keys into and gets a determination of whether the new employee is eligible to work in the United States based on the records of the Social Security Administration and the Department of Homeland Security. It is required today in limited circumstances, particularly for government contracts. Historically, it's been a political battle between the Republicans who favor E-Verify and the Democrats who oppose E-Verify, or at least want something in return for agreeing to making E-Verify mandatory. And that something in return was typically some sort of an amnesty program. President Bush tried very hard to institute E-Verify for everybody and was unsuccessful. The Obama administration made no effort to make E-Verify mandatory, as far as I'm aware. But I think that this is something that can be expected from a Republican administration. It will require an act of Congress, and I think it'll have support. I think it'll have general support on the Republican side of the aisle, and if the president decides that that's part of his immigration package, I think we're going to see that. So we may see a system whereby every employer must verify the authorization of new employees to work in the United States. Right now it's voluntary. You sign, the companies that want to do it for one reason or another will sign a memorandum of understanding and be required to do it for all new employees. You're not allowed to do it for current employees, only for new ones. Okay, prediction number 3, the H1B program and other programs that allow temporary foreign nationals to work temporarily in the United States. The H1B program is a program that's available for professionals who are filling professional positions and being paid the prevailing wage. Those are the 3 requirements for H1B. Now, today, there are approximately 85,000 H1B slots available. They become available the first day of the government's fiscal year, which is October 1st, but the regulations provide that applications can be filed 6 months before the start date. So if the earliest start date is October 1, applications are filed on April 1. So what's resulted over the last several years is that the government conducts a lottery for H1B visas on the first week in April. This year it'll be on April 3rd. And they typically allow you to submit these during the whole first week. Used to be they had to be in on the first day, and the government was overwhelmed. So they've extended it during the entire week. After the first business week in April, the government conducts a random selection process of applications, because last year there were about 230,000 applications for 85,000 slots. So you can figure out for yourself what your chances are. It's a little more complicated, because if the employee has a master's degree from a U.S. university, then they have 2 shots at it. There's a special 20,000 they can get selected in that lottery. If they don't get in that lottery, then the regular 65,000 they can get selected there. But what I'm suggesting here is that there are going to be new requirements for what's called dependent employers. Those employers that have a lot of H1Bs, they have to regularly test the labor market. Congress is probably going to evaluate whether the 85,000 number is right. The prevailing wage determinations, in other words, I said earlier that an H1B has to be paid comparable to what U.S. citizens are paid for similar work and in the location based on Department of Labor statistics. At the moment, the employer can select, subject to audit by the Labor Department, can select what the category of the position is and what level it is, and try to line that up with the wage that they're actually paying. Site visits, right now there are typically site visits after an H1B is approved to see if the business really exists. I think we're going to see more of that, and perhaps an increase in the pre-adjudication site visits. And finally, colleges and students should expect increased scrutiny at consular interviews. This is going to be this is going to be an important topic for something that this is a category of individuals who are regularly attracted to the United States to study. When you come to the United States to study, you have to convince a consular officer that you are in a program that's appropriate for you, that you're going to return home after you're educated, and that you have the financial wherewithal to complete the program. That you speak English if English is necessary, and those kinds of things. And every step of the way, the acceptance by the school, the application at the consular post for the visa, the entry to the United States, the registration for classes, it's all monitored on something called CVIS, which is an interbase tracking network that the schools key into it and present the information. The Department of Homeland Security keys into it to tell the system when the person has entered, when the person has left, and it's used for enforcement. It became a priority after 9/11 when it became known that there was really no tracking or enforcement of students. Some of the perpetrators of 9/11 were students, and everything at that time was paper-based, and basically there was no enforcement. They're also I'm predicting there will be limits on employment opportunities for students. As many of you know, if you have a client who employs students in something called OPT, optional practical training, that's a opportunity for students to work for, in most cases, 1 year after graduation for a U.S. company, and in cases of in special cases where you have a STEM graduate working for an E-Verify company, it can be up to a total of 3 years. And there is talk about restricting that. And I think we're going to see that as part of the Trump administration initiatives to bring that back to perhaps 1 year or perhaps eliminate some of those opportunities. Okay, I'm talked to myself here for 31 minutes, or about 30 minutes. If there are questions about immigration law or if there are any questions about immigration law, I'm happy to answer them. I don't see any on the chat line. Oh, wait, maybe I'm looking in the wrong place. Nope, I don't see any in the chat line. Okay. Am I? Somebody asked me a question so I can see if my chat line's working. Okay. Okay, so far no questions on the chat line. Okay, thank you for explaining. You're welcome, Mr. Okay, what do I anticipate in terms of immigration reform? That's hard to know because if you listened to the speech last night, you saw that the President was talking more like reform than enforcement. What needs to be done in immigration reform, frankly, is to adjust the number of opportunities for people to come to the United States. The system has not been changed since 1986. We're still operating with the same number of opportunities of visas available, either permanent. Let's talk about permanent resident visas. The way some of our grandparents or great-grandparents came to the United States really doesn't exist anymore because there are only 10,000 visas available every year, 10,000 green cards available every year for unskilled workers. So what's happening, of course, is that unskilled workers see no way to legally enter the United States, so they enter illegally, or they come as visitors and overstay and take jobs. And that's part of the message that gets left out of the dialogue, and that is, the dialogue says, well, these people didn't play by the rules. Well, I think what Congress has to come to terms with is there are no rules to abide by because there are virtually no opportunities for unskilled workers to come to the United States. And so I think immigration reform has to include that. It has to, and immigration reform could include a system like they have in other countries, where in this country everything is employer-driven. In order to obtain a green card in the employer, there are 3 ways to get a green card: family relationships, asylum and refugee, and employment-based. In the employment-based world, everything is employer-dependent. The Department of Labor requires that employers pay for the legal and filing costs associated with the process, or at least part of the process, the part that's controlled by the Department of Labor. And that makes it difficult for employers because as soon as the employee gets his green card, he's free to leave. So why should the employer invest in this, particularly in the unskilled worker category? So on the one hand, you have unskilled workers unavailable. You have employers being forced to pay for it. The system should somehow recognize the country's needs and the skills or the abilities of the immigrant that will that are necessary in the United States, something like a point system like they have in Canada. So I think that has to be part of immigration reform. Do I think, okay, somebody just posted that question. Do I think that we'll follow Canada's? I don't think we will follow it to the extent that Canada has it. That would be a rapid departure from the way we've been doing business, and I don't think that's going to happen. But I think there has to be some recognition of, today we have classifications for people who are at the very top of their field, extraordinary ability, outstanding ability, outstanding professors and researchers, people whose work is in the national interest. Some of these people can self-petition, meaning that there's no employer involved. But you really have to be at the top of your game in order to qualify for that. And in the academic world, it's much easier to prove that than it is in the business world or in the professional world. So I think you might see, if there's a serious effort at immigration reform, you might see some of that coming into play for people lower down in the accomplishment chain, let's call it. Okay, do I think that DOL will alter labor certification review practices? Appears the administration to concern heightened scrutiny on questions of qualified U.S. workers. Yes, I think the Department of Labor is going to be instructed to employ a higher level of scrutiny. I think that if the administration is serious about the things it's talking about, I think you'll see the Department of Labor instructed to increase the percentage of audits that it's going to, and probably, I mean, this is probably I don't know much about what happens in the Department of Labor, but I imagine they monitor the percentage of approvals. They're going to take a good look at that, I would imagine. But yes, I do believe that there will be a higher level of scrutiny on the question of whether the question here is posed to the qualified U.S. workers. It applies also not only to whether the worker is qualified, but as to whether the employer has done what is necessary to effectively test the U.S. labor market to establish that there's no U.S. worker available to fill the position, which is one of the ways, the principal way in which businesses bring people to the United States, bring foreign talent to the United States. And there's a mandated test of the labor market. You have to follow a certain recipe in the regulations, and many of these cases are approved. Just like your tax return is approved without audit, many of these cases are approved without audit, and we may see a change in that. We're leaving the NAFTA with Mexico affect immigration, specifically Mexico and U.S. I suppose it could. I'm hopeful that it won't. I don't know that leaving the NAFTA is, I don't know what the status of that is, but technically, let me explain for those who are familiar with this. There are special opportunities for Canadians and Mexicans who are basically professionals to enter the United States. This is a welcome tool for those who are shut out of the H1B program because of the lottery. Canadians and Mexicans who are in one of a whole lot of enumerated classifications of, particularly engineers, but there's a lot of classifications of professionals that can qualify if you have a degree in the field, you're filling a position, you have a business opportunity in the United States, you can come from Canada or Mexico, and there's no quota, there's no prevailing wage. Will that change? I hope it won't, but I just can't predict. I just don't know whether it will or it won't. I think I've covered all the questions so far. Okay. I don't see any more questions here.
Thank you, Joel.
Okay.
That was wonderful. Oh, I think you just got one more if you want to grab that
one
let's
see.
Before we close out.
Oh, of course. Question is, would I agree conservative recommendation to employers with valued non-immigrants that they should soon pursue green card process? Yes, we've recommended that for a long time. The green card process is something that it's a decision that needs to be made by an employer because of the costs involved that are imposed on the employer. But yes, I think that is a very valid recommendation. And we've always looked at life that way, that if you have a valued non-immigrant employee, that you should do something about obtaining a green card. The problem is that once they get the green card, they can leave, and you have undertaken certain costs involved in doing that. That's just a business decision as to whether the employer does it. But I think the time is right for that. I think that we're looking at a time when the government has not taken any action with respect to nothing has changed. Let me say this. Of all the things that have changed, nothing has changed in the way the these cases are adjudicated, either the Department of Homeland Security that has jurisdiction over some cases, or the Department of Labor that has jurisdiction over many cases. Nothing has changed in the last 40 days. It's going to take some time for those processes to change, and if they are changed we're in a way that will make it more difficult for people to get green cards, might as well get in now when the getting is good. Or it's not good. Compared to what it once was, it's not good, but compared to what it might be, yeah, it's good. Time to get in. Do I anticipate LPR's exclusion from new order? Yes, I do. In other words, you're asking whether or not lawful permanent residents or people with green cards will be excluded from any travel ban. I believe that the government announced that they were excluded from the prior travel ban. What other exclusions do you anticipate besides DACA and DAPA? Well, I think anything that mentions the word religion will be excluded. Again, I think that much of the what will result from the new executive order on travel ban, I predict will be what's unsaid, not what is said. So this is historically there have been different ways that consulates have adjudicated visa applications at different posts for different nationalities. There are all kinds of cases that require special administrative processing and approvals from Washington, and we might see some of that. We might see some of that in these new executive orders. I mean, there are lots of innocent people with no for no reason are detained abroad while somebody goes through some process that's highly secretive, obtaining approval for this person to be granted a worker visa or an H1B, for example, to return to the United States after they've been here for a couple of years. They apply for a new visa. They call it administrative processing, and it's typically keyed to people who have knowledge that might be that the government does not want shared with a foreign country. If they come to the United States to work in this position, will they gain knowledge that we don't want them to have? But this has been going on for a while, and I expect we're going to see more of it. Okay. All right. You're quite welcome to all of those who thanked me for the presentation. Crystal, if there's nothing else, we'll say goodbye.
Yes. Yeah, thank you. Thank you very much, Joel. That was a great presentation. Just a reminder for everybody, I just wanted to let you know that I will distribute a copy of this presentation as well as a recording of the webinar and Joel's contact details in the next few days. Feel free to reach out to him directly. Feel free to share the recording with other people at your companies, your firms. With that, I think.
Okay, thank you all for your attention.
Yep, thank you. Have a good day.
All right, bye-bye.